We've been discussing how public school administrators seek to balance the rights of students against our need to maintain safety, order, and discipline in our schools. But how about the kid that sits in the back of your classroom who just won't shut up? And when you tell him to, his response to you is, "You can't tell me to be quiet. I have the right to free speech." How do you respond to that? How about the kid on the other side of the room who says, "Man, we don't have any right to free speech. We're just kids and this school is like a prison." Is he right? Do students have the right to free speech inside your school? Just how does the First Amendment's guarantee of free speech apply to public school students? Answering these questions helps us differentiate between protected and unprotected speech, as well as examine the differences between private and school-sponsored speech. And, as you would expect by now, we turn to the courts for some answers. The first case we can look at is Tinker versus Des Moines from 1969. 15-year-old John F. Tinker, his 13-year-old sister, and another 16-year-old student attended school in Des Moines, Iowa. The three were among a group of adults and students who objected to the Vietnam War, and they planned to wear black armbands throughout the holiday season. School officials became aware of the plan and decided to suspend any student who refused to remove the armband. The three students wore the armbands and were, as promised, suspended. One of the most famous education-related court cases in U.S. history would ensue. At issue was whether or not a public school can suspend students for wearing armbands of protest without violating their First and 14th Amendment rights. In this case, the court decided that the school's actions were in fact unconstitutional. This was a landmark decision. The court's majority opinion was that armbands were symbolic speech and closely akin to pure speech. This yielded one of the more famous court statements authored by Justice Abe Fortas. Students do not give up their constitutional rights at the schoolhouse gate. Fortas went on to state that First Amendment rights must be applied in light of the special characteristics of the school environment, and that student speech may not materially or substantially disrupt school or substantially interfere with the rights of others. In this case, they didn't. In other cases, they have. Almost 20 years after Tinker came the case Bethel versus Frazier. This 1986 case dealt with Matthew Frazier, a senior at Bethel High School in Washington. Frazier delivered a nominating speech for a student government candidate that was based largely on a sexual metaphor. He had been informed by two of his teachers that his speech was inappropriate and was advised not to give it. Frazier, a star debater, delivered the speech anyway. Some students at the assembly hooted and yelled or made gestures that simulated the sexual references in the speech, while others were just bewildered and embarrassed by it all. One teacher claimed that she had to deviate from the scheduled lessons the next day to discuss the incident. The morning after the speech was delivered, an assistant principal called Frazier to her office and informed him that he was suspended for 3 days and that he would not be a candidate to speak at graduation. Frazier appealed through the school processes and lost. Although he was allowed to return to school on the 3rd day, Frazier filed suit, stating that the action violated his First and 14th Amendment rights. The court was faced with the following question: is a student's lewd or offensive speech at a school-sponsored event protected by the First and 14th Amendments? The answer was no. The majority opinion stressed that the mission of public schools is to communicate and inculcate community values. The freedoms of the student must be counterbalanced with society's interest in teaching students socially appropriate behavior. There's nothing in the First Amendment, the court stated, that prevents school officials from determining that a vulgar and lewd speech undermines the school's basic educational mission. Our third student expression case is 1988's Hazelwood versus Kohlmeyer. This case involves the right of the school to control the content of a school-sponsored newspaper. The Spectrum was the school newspaper produced by students at Hazelwood East High School in St. Louis. While reviewing proofs of an upcoming edition, the school's principal objected to 2 articles that were to appear. One dealt with the experiences of 3 pregnant students, and the other dealt with the impact of divorce on students at the school. The principal objected to the first story because of concerns that the pregnant students would be identifiable even though their names were withheld. He also felt the discussion of sexual activity and birth control were inappropriate. The second story was objectionable because of negative comments made by one student against her father. The principal felt that the father should have had an opportunity to respond. The two articles were deleted. The question that arose was, do articles written by students for school publication enjoy the same protection under the First and 14th Amendments as other forms of public expression? According to the court, the answer is no. The court first dealt with whether or not a student newspaper is a public forum in which free speech is allowed to flourish. The school board policy, as well as the principal's policy of prior review, established that it was not an open forum. Further, the school's journalism advisor exercised almost total control over the publication. More evidence that the Spectrum was not an open forum. After establishing it as a closed forum, the court distinguished this school-sponsored speech from that at issue in Tinker, which was student to student. Tolerating private student speech is different from compelling a school to affirmatively promote controversial speech. A court determined that the school was justified in regulating student content and style in school-sponsored activities, as long as their actions are reasonably related to a legitimate pedagogical concern. So here's the case law that we gain from these three cases. From Tinker, a school district may not suspend students for wearing symbolic armbands as protected by the First and 14th Amendments unless there is a material disruption or an invasion of the rights of others. From Bethel, student expression that is lewd, profane, or indecent is not protected by the First and 14th Amendments. And from Hazelwood, a public school may censor a school-sponsored student newspaper's contents as long as the newspaper has not been converted to an open forum and there is a legitimate pedagogical concern. These three cases show a shifting judicial philosophy with regard to student expression. Prior to Tinker, schools basically operated under the legal principle of in loco parentis. In other words, schools had the same ability to control student behavior and speech as parents. Tinker changed that. However, the students' rights movement, some would argue, began and ended with Tinker. Though Tinker is still good law or binding precedent, the holdings of the court in Bethel and Hazelwood have etched away at student expression little by little. In order for speech to be considered protected, it must be either actual or symbolic expression that is meaningful to students and other persons within the school community, and convey a message that is likely to be understood by those who view it. If it is lewd or vulgar, as we learn from Bethel, it is not protected. If speech is not protected, it can be regulated by schools on a rational basis. In order for a school to regulate protected inter-student speech, it must meet the Tinker standard of showing that the speech caused a material disruption or an invasion of the rights of others. In short, the First Amendment is designed to protect political and religious expression that, because it is unpopular or in the minority, might otherwise be suppressed.